All right, welcome everyone. I hope you're enjoying your lunches. I'm very pleased today to introduce Carlo Amatucci, who is a professor at the University of Naples, Federico II. And he comes to us with a very topical issue that is directors' duties, or rather regulation of directors in financially distressed companies. He's in particular interested in some comparative notes, in particular comparing the way in which law addresses the conflict of interests between shareholders and managers on the one hand side and creditors on the other hand side. I'm very pleased, Carlo, that you're taking a comparative approach. I think it will be very informative.
I'll try.
And we're very happy to have you here. And Carlo doesn't only know about the academic side of directors' duties, but he's also a practicing barrister solicitor. So he really knows what he's talking about. And we'll, as usual, we'll have half an hour of presentation, roughly. And then there will be time for questions and discussions. So, Carlo, the floor is yours.
Thank you.
I'm looking forward to your presentation.
Thank you very much.
Thank you.
Thank you very much. I'm very happy to be here, and thank you. I particularly thank Dr. Mark Moore for inviting me, for having me here, this prestigious university. And actually, it's a long time since I was here doing research in 1998 and 2000. I was assistant at that time, and I was doing research in this great university. So I'm particularly happy and delighted to be here again as a speaker. And I'll try to do my best to introduce this topic that has to do with the so-called twilight zone in which companies can find themselves when they experience financial distress. And as my colleague has just said, there is a conflict of interest that becomes relevant and very visible when the crisis starts, but the company is not insolvent. Although the fact that we say the crisis approaches, the crisis starts, or the company becomes insolvent, seem to be clear concepts, but they are not. They are not for economists, neither they are for legal scholars. What is clear is that when this twilight time comes, and we will see how important is the rule of time in this matter, when this happens, shareholders may benefit from high risk and high reward decisions, because they are those who less have to lose in these cases, compare with creditors, which on the other side may prefer that managers would take more risk-neutral or low-risk decisions that increase the probability of some recovery. Once the shareholders' equity has been vanished, has been dissipated, or has been reduced to a very low level, and there is no prospect for its being rebuilt, the incentive for company managers is to take, as I said, to take on very risky projects, because they rather pay attention to the potential upside of those decisions. Projects with a negative present value may be undertaken as insolvency approaches, and the downside risk of such projects will fall on the company's creditors. But when we refer to creditors, we have to pay attention especially to those who are unsecured creditors that come next in line to shareholders in bearing companies' losses. In any insolvency situation, we could say, in other words, that managers, directors are playing with creditors' money. We have to consider the important factor of limited liability for shareholders that becomes extremely relevant in this period of the life of the company. So anything that managers do to increase or decrease shareholders' equity goes to the benefit or to the detriment of creditors rather than shareholders. Obviously, until the company regains solvency. So in the twilight zone, directors may also have another great temptation, which is to divert assets out of the company so that creditors can no longer lay their hands on them. And so there is a general principle in all jurisdictions that directors should not take unjustified risks to produce value for shareholders, which can turn out to be negative for creditors. This is a general and undisputable principle of all jurisdictions. The problem comes when we look at the solutions, at the strategies that jurisdictions follow. And obviously those that now you can read are the main strategies that jurisdictions try to follow, sometimes mix them, not necessarily choosing one of them. And in a kind of mixed order, the first duty that seems to be very popular in many European jurisdictions is the obligation for directors to file for an insolvency proceeding when the company comes to a certain point. And again, let me stress this aspect. When the company comes near to the insolvency. I'm not saying when the company is insolvent, that's the problem. But when the company comes near the insolvency. The second specific, quite common in some jurisdictions, like the United Kingdom one, has to do with liability for directors who act in the so-called wrongful trading. They violate the wrongful trading prohibition. And we will see, changes to the content of directors' duties is number 3, which seems to be, of these 4 strategies, to my view, the most vague and difficult to be effectively considered. And finally, another very common rule in some European jurisdictions, especially Germany and Italy, which is the recapitalize or liquidate rule. That I can anticipate, to my view, is not a rule for the neo-insolvency problem, but rather is considered in those 2 countries a rule when the insolvency is very clear and when the insolvency has come and maybe it's too late to do anything to recover. So as I said, most jurisdictions employ 1 or 2 of these strategies to ensure that creditors' interests are taken into account in this particular moment. The first strategy, to timely file for insolvency, is triggered by the insolvency of the company, rather than merely a threat of insolvency for the company. And this strategy is often reinforced by directors' liability for the depletion of the company assets resulting from the delay of the insolvency filing. What can be said about insolvency in a few words, since I am mentioning several times the pre-insolvency or the insolvency moment for the company? The main approaches established are the balance sheet test and the cash flow test, considered by some European jurisdictions, especially Italian and German, but even the British legislation. The wrongful trading takes into consideration the moment when there is an excess of liabilities of assets, or there is the incapacity, the inability of the company to meet its debts and liabilities when they become due. I will go very, very fast with regard to wrongful trading, since all of you know what it's all about. I mean, it has been of interest for a continental scholar like me to know more about wrongful trading and to see how this rule seems a very flexible and manageable rule from the continental side of the of company law. The section 214 exposes to personal liability directors of a company who, at the point that they realize or ought to have realized that the company had no reasonable prospect, failed to take all steps which a reasonable director would have taken to minimize the potential loss to creditors. And this is a very clear definition that I found in this excellent article written by Professor Davis. In other words, a company is engaged in wrongful trading if it incurs in liabilities with no reasonable prospect of meeting them. To an Italian lawyer, it would seem this rule exposed to the interpretation of the court, because the problem would be, what's the meaning of reasonable prospect to meeting liabilities? When is the time, actually, when is the time when this prospect becomes unreasonable? When is too early and when is too late to act? And the personal liability for the director comes from the fact that he knew that trading was unlawful and that trading was increasing companies' liabilities rather than helping companies' wealth. Action against directors, again, this is an interesting term, may be brought only if the company goes into insolvent liquidation, and clearly by the liquidator. I will tell you why. Director, obviously, who are considered to be liable for the wrongful trading, will have to contribute but it has been argued that this rule does not operate far enough in advance of insolvency. Insolvent liquidation seems to be based on a balance sheet basis. Going into liquidation at a time when assets are insufficient for the payment of debts and other liabilities. Again, the problem is when actually the company, according to UK legislation, when the company becomes insolvent. From one side, I said it's a very manageable and efficient rule. It gives directors powers to adapt each case and to react in a proper way according to the company's situation. But on the other hand, this freedom can be interpreted in a quite contradictory way. It could be interpreted by a court. Going into insolvent liquidation does not define the point at which creditors regarding duties are triggered. Again, the problem of triggering, the problem of starting these remedies. The whole rationale of the section requires that these duties should be triggered at an earlier time. We will see how big is the difference when we consider the Italian system. When these things happen too late, absolutely too late, and everything has been done, and maybe nothing can be done again. But this will be clear only when I will explain Italian rules compared to the wrongful trading principle. And here comes the legal capital protection, the strategy number 3, that, as you probably know, gives much weight to the role of capital in limited liability companies. And this happens in Germany and in Italy, particularly. But we will see that the legal capital protection, that is a clear institute of those countries, has little to do with the twilight zone of the company. Has much to do with the protection in general of creditors. Because in these countries, in many European continental countries, the use of contractual substitutes, like I call the covenants, is absolutely very, very rare. And I would put on one side covenants as an instrument for creditors to protect themselves, and on the other side the rules on legal capital. But both instruments don't have much to do with the pre-insolvency problem. They more have to do with the role of creditors' protection in general, but not in that particular moment when the crisis is approaching. I would say that maybe my colleague from Palermo can confirm this, very few Italian companies use covenants. Very few. And very large companies. This means that on the legislation and in the real practice, Italian companies still rely much on capital rules, despite the debate that it's going on for many years, where scholars made clear that maybe time has come for the capital rules to be reconsidered or to be abandoned, opting for a different strategy. Here comes what I found to be an important piece of German legislation that I'm sure most of you know, especially my colleague from Germany. It makes clear in a few words which are the obligations for directors, especially the obligation to start insolvency proceedings at the latest within 3 weeks of the company becoming insolvent, even if its legal capital is unimpaired. For instance, this rule doesn't exist in my country, and this would probably never happen. The principle may be found in the Italian legislation, but I can tell you that no directors would ever ask for insolvency proceedings if the capital has not been lost. Instead, in Germany, this could happen if company's assets, while exceeding its liabilities by the amount required by the applicable legal capital rules, were illiquid, so that the company could not pay its debts as they fell due. So this means that legal capital rules are not what I tried to anticipate a few minutes ago. They are not a substitute for rules directly addressing controllers' incentives in the vicinity of insolvency. Legal capital rules do serve other objectives. They don't seem to me as a strategy for the problem we are addressing today. Article 92 of the Aktiengesetz requires the Vorstand to take action where or shortly after the company becomes insolvent on either of the two tests for insolvency, the balance sheet or the cash flow. And even here, I would stress another difference with the Italian legislation. I don't think that we have any provision comparable in Italy, comparable to 92 of the German jurisdiction. Legal capital rules, probably with little success, aim to prevent the incorporation of inadequately capitalized companies in the moment when the companies are founded, when they are set up. Rules focusing on controllers' incentives near insolvency do not procure adequate capitalization, but aim to restrict the harm caused to creditors by the phenomenon of the undercapitalization. But this is again something that has to do with time, when the company is born, when the company, in those systems like Italy, that still rely much on the capital rule, this means to give the company enough capital to start the business. The problem is that in the last 5 or 10 years, especially after the crisis struck our economy, we assisted to an increasing devaluation of our minimum of capital, because the civil code provides a limit, a minimum capital for the stock company and for the società a responsabilità limitata, the small limited liability company. And the capital limit, the capital minimum, is only 50,000 euro for the società per azioni and 10,000 euro for the limited liability company. I found out that when in 1942 the civil code was approved, and most of the legislation still relies on that code, notwithstanding the reform of 2003 and 2004 for limited liability companies, the value of the minimum capital for the società per azioni was something comparable to 1 million euro today. So we can see the difference between the role of the capital in the 1940s and today. There is a clear contradiction. If we look at the number of rules that the civil code still contain regarding the effectiveness of the capital, and how is the capital formed when the company is born, and how is the capital kept during the life of the company. all these rules seem to be contradicted by the very low value of the company. What I'm trying to suggest is that with a minimum legal capital of only 50,000 euro, a small business operation can cause an immediate insolvency of the company. And there is no time to give directors any power, any time to adopt what the civil code wants. And we will see in a few minutes which are the rules that the civil code requires to the Italian directors. Just a few lines about the general duty of care and duty of loyalty in the Italian system. And obviously the specific duties that can be set out in the company's articles of association. If these duties are breached by directors, consequences are clear. Responsibility of directors towards the company and the shareholders, and also 2395, responsibility for the direct harm caused to the single shareholder or to the third party. And finally, probably the most interesting liability of directors in the Italian system, the company's creditors. Company's creditors, power to directly sue. We will see when directors, when they do something wrong about creditors. In the event of insolvency proceedings, the court appointed the receiver who can bring these actions against directors. Let's have a look at this basic rule that has to do with capital. When losses reduce it by more than 1/3, consequence is very little. Directors just have to call a shareholders meeting. They must submit a report to shareholders. If losses are not reduced by less than 1/3 within the next financial year, so pay attention to the long time that is required by the code. 1 year to see if those losses are reduced. In that case, if shareholders' meeting does not approve this reduction, directors and statutory auditors must request the court to order the reduction of the capital. The legislator gives this 1 year time to see if those losses can be reduced. If they are not, the capital must be, the value of the capital must be reduced. This is the second rule of the Civil Code. The rule that applies when losses hit the minimum of the capital, the 50,000 euro I said before. In this case, an urgent meeting must be called by directors, either to approve the reduction of the capital and obviously the simultaneous increase to no less than 50,000, because below 50,000 the companies cannot survive, or to decide the transformation of the company into a different type of a company, a partnership, for instance. If the shareholders' meeting does not approve the reduction, the increase of the capital, or the transformation of the company, then liquidation is inevitable. And that's the point where many directors fall. They do something in the company's accounts not to show the real losses of the company in order to avoid the application of this rule, in order to avoid the risk that the company would go to liquidation. If the general meeting approves the liquidation, then directors must manage the company for the purpose, only for the purpose of preserving the value of the assets. But consider that this is happening when a company has completely lost its capital. This is the only duty, the duty to preserve, the duty to avoid further losses. But the capital has gone, and the liquidation is inevitable. After the debtor is admitted, if there is the opening of an insolvency proceeding, not necessarily liquidation goes to court, but if there is an insolvency proceedings, directors may be held criminally liable or civilly liable for damage if they breach the duty not to delay the declaration of bankruptcy, the so-called deepening insolvency, something similar to deepening insolvency. Again, it's not clear when Italian directors should do something to avoid the deepening insolvency. And the duty to avoid payments or creation of securities in favor of some creditors, but that doesn't have much to do with our topic because it touches the principle of par condicio creditorum, the duty to preserve equality among creditors. Directors often try to avoid filing for insolvency. They try normally to investigate the chances of restructuring the company. Italian jurisdiction offers now, especially after the crisis, several ways, several instruments to avoid the real insolvency proceedings. But these proceedings, these pre-insolvency proceedings, take time to be decided, take time for the court to approve them. Meanwhile, if companies' accounts are not reliable, big damage can be done to the company. An excessive delay in filing for insolvency may entail criminal and civil liability. And so when the insolvency becomes definitive, irreparable, then directors have the duty, this is what the criminal code wants from directors, even to avoid the injunction, the investigation for what we call bankruptcy crimes. And now we come to what I told you before seems to be the only provision in our civil code, provision originally made in 1942, never changed, which is Article 2394. Directors are liable for not observing the duty to preserve the company's assets always during the life of the company. And so if they violate this obligation, and if the assets of the company prove to be insufficient for creditors' claims, they can be responsible towards creditors. But the problem of this provision is that it requires necessarily something wrong. It requires the directors to do something against companies' assets. If there is not a wrongdoing, there won't be any liability from director's side. And the nature of wrongdoing is very disputable in the court tradition of Italy. Difficult to say when the director did something wrong to the assets in order to be directly liable towards creditors. It's an important principle, to my view, for a director. And it has something to do also with the principle of wrongful trading in this country. The duty of directors to take care always of creditors, especially when the company becomes goes into a financial crisis. It seems to be a provision that was cleverly introduced. The only problem, as I said, that it requires a specific wrongdoing on the side of the director, which means that these are the important behaviors we are talking today. Disregard of any action to cease business operation when the company is in the twilight zone, or taking any, as we said earlier, unjustified risks to produce value for shareholders to detriment of creditors. So these two important things, unfortunately, and notwithstanding the efforts of our scholars, of many Italian scholars, who tried their best to say that 2394 applies to these cases, my personal view is that it doesn't apply. It doesn't apply to these two cases, when directors continue to trade and when directors take unjustified risks. There is nothing we can do with 2394. So Italian regulation does not expressly require directors' fiduciary duties to include creditors as a constituency when the company comes near the insolvency. It does so only when the insolvency has arrived. May be too late, but this is the rule. This is the rule done in 1942, so when the economy of the country was completely different, when Italy was mainly an agricultural country, not an industrialized country, but it has the merit, this rule, to contain an important principle, the principle that directors have to take care of creditors all along the life of the company, and especially when the company goes into troubles. But how can creditors react to the violation or to the breach of this duty is very hard to say. There are some sentences that found directors liable on this ground, but there are very few, in the lack of any wrongful doing from their side. Thank you very much.